rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is one CACV 23-0635, Douglas Barrett and Lori Barrett versus Landmark Ceramics et al. This is the time set for oral argument. As a reminder, this hearing is being video and audio recorded. In a few days, the video will be posted to our YouTube channel. Counsel, before you begin your argument, please identify yourself and the parties that you represent. Each side will have 20 minutes. If appellant's counsel would like to reserve time for rebuttal, you're required to keep track of your own time. We have read the briefs and conferenced the case, so we are familiar with the issues. There's no need to repeat what's in your briefing. And with that, counsel, you can proceed.
Thank you. May it please the Court, Chief Judge. I will emphasize 3 issues that should be decisive of this case. The first one...
You haven't announced for the record.
Oh, I'm sorry. My name is Carmen Horn, and I'm the attorney for the appellants. May it please the Court. I will emphasize the 3 issues that should be decisive of this case. The first one is the mediation agreement. It is a binding agreement, and it's not a term sheet that the appellees say that it is. A term sheet does not appear in this case anywhere. And the appellees are trying to justify reneging on a binding agreement. The first sentence in the agreement says that I can't read it from here. Sorry. Plaintiffs and defendants have reached the settlement at the settlement conference before Judge Pro Tem Paul Stoller on this date. By their signature below, the parties affirm that they have agreed to the terms of this settlement, which includes resolution of Maricopa County case number 2018-056939. That's paragraph 1 of the mediation settlement agreement that we're talking about today. 7 states, in the event of a dispute between the parties as to any terms of the definitive settlement documents, the parties agree that Paul Stoller shall be the final arbiter of any such disputes, and there shall be no right to appeal of any such decision by Mr. Stoller.
So, Ms. Horn, you just read paragraph 7, right?
Yes.
So paragraph 7 refers to arbitration about definitive settlement documents, correct?
Correct.
Would that be referring to an agreement separate from this document? Since it's referring to definitive settlement documents, is that separate than this agreement?
No, it isn't, Your Honor. May I put up another board?
Well, you can refer to whatever materials you'd like to refer to.
Okay, all right. Well, the entire mediation settlement agreement has 7 points in it. Number 1 is the intent to be bound. Number 2 through 6 are material terms that the parties agreed to. And number 7 is that if there's any dispute as to the terms of the mediation agreement, then there's an arbitration. In effect, the mediator, Judge Stoller, ends the mediation.
That's my question, is the term 7 talks about arbitration of a definitive settlement documents. Seems to talk about documents other than the 4 corners of the mediation settlement agreement.
No,
that's what I mean.
No, Your Honor. It is within the 4 corners of this. And 2 through 6 are all the material terms basically for the settlement agreement. And in fact, on that date, May 18th, all the parties signed it, the plaintiffs, the defendants, the attorneys, and Judge Stoller. And in there, if you look at term number 1, it says in there, by their signatures below, the parties affirm that they have agreed to the terms of this settlement, which includes resolution of Maricopa County case number, that number. So 2 through 6 are up on another board, and basically 2 through 6 enumerate the material terms of that settlement agreement. So what happened is that the defendants reneged on the agreement. There were disputes about turning this mediation settlement agreement, which is very normal if you had...
But there were other terms that had to be hammered out, correct?
Not necessarily. This agreement should have been binding on all the parties. If you renege on it for whatever reason, and we don't have anything on the record what those reasons were, then paragraph 7 says, in the event of a dispute between the parties as to the terms of this settlement document, which 2 through 6 enumerate all the material terms, then at that point, the mediator becomes the arbiter. I mean, normally you have your mediation, you end it, and you have a settlement document, and it is very typical for the arbitrator to say, or the mediator to say, okay, you guys, fill in the final terms to make it into, a final agreement. That is very typical. If there's a dispute or somebody reneges, breaches that settlement agreement, which is what they did, then the mediator says he becomes the arbitrator of the dispute. Otherwise, we would have havoc in the judicial system. Can you imagine if every settlement agreement, when they have a dispute, then you have to go to another court to figure it out, which is what we ended up having to do. So this document in its entirety is the mediation settlement agreement.
Let me ask you a question about the issue preclusion.
Yes, go ahead.
Are you challenging your client's opportunity to fully litigate the enforcement of the settlement agreement for issue preclusion purposes?
We don't think that it should be precluded. What happened was...
Right. I get that. But is part of that challenge because your position is your client did not have an opportunity to fully litigate the enforceability of that agreement?
Yes.
In your brief, do you talk about that?
Yes.
Where in your brief do you make that argument?
The reply brief really outlines it better than anywhere else on pages 2 and 3. It's also, and it's because the appellees raised it, right? They're agreeing with this. What happened was the mediator refused to mediate because there's a dispute and he didn't want to get into it. He could have just affirmed the mediation settlement agreement. So we filed in the same court, Superior Court, a motion to enforce the agreement. And in that court, the judge, she said, go ahead and file a new lawsuit. That is your remedy. Go file a new lawsuit. So we did what the judge said to do. Go ahead and file a new lawsuit. And then that judge looked at the lower court's decision where it had dicta in there about the lower court thought that maybe it wasn't enforceable, and then the lower court judge also at the same time said, file a new case. So our position is that inconsistency, it doesn't make sense for the judge to say, file a new case, if she meant that dicta to be part of the ruling. It doesn't make any sense. And we cite...
Did you appeal Judge Agne's statement or determination, if you will, about the enforceability or lack of enforceability of the agreement?
Yes, Your Honor, we did appeal it, and the Court of Appeals never addressed the issue of the substantive issues. The Court of Appeals basically dismissed procedurally because they thought that the case had been dismissed and it hadn't been.
You agree that the issues were raised in the Superior Court. The issue that you're now seeking to raise that it was raised in the Court of Appeals, but you're saying the Court of Appeals didn't.
They didn't address it.
Right, but the Superior Court did and said there wasn't an enforceable agreement. It was an agreement to agree. Is that?
Well, let me address that, okay? Because first of all, the appellees in their briefing never addressed the issue that the lower court judge said for us to file a new case to enforce the agreement, and it can't make sense, Your Honors, that a judge says go file a new case because that is you have to do that in order.
Did the court direct you to file it, or was that just the representation that this will force us to go file a new case?
In Appendix 2, in Appendix, Appendix 4, that's the lower court's decision, and here it is on the board. This is the Superior Court decision. In the same email, Plaintiff's Counsel states, if there is a necessity to sue to enforce the arbitration agreement, that will be a separate lawsuit. Plaintiff's Counsel, through staff, again admits plaintiff's contemplation of a new separate lawsuit. When Mr. Horn was about to file a new lawsuit, the applicable authorities required the court, meaning the Superior Court where we filed the motion to enforce the settlement agreement, the applicable authorities requires the court to leave plaintiffs to that remedy, meaning file a new case. So that was the holding of the Superior Court. It
doesn't necessarily say what will happen when you do it. It just says we're going to leave you to that remedy.
Correct. And then the new court where we filed the case to enforce the arbitration agreement, the new court basically said you're collaterally stopped, res judicata, and the appellees didn't address that issue in their response. So in the answering brief, they did cite Pioneer versus Rich, 179 Arizona at 462, in which this Court of Appeals stated that it had to interpret whether a particular statement, so the lower court statement that this agreement may not be enforceable, was preclusive in subsequent cases. Note that this court did not state in Pioneer that the mere inclusion of part of an order makes it preclusive. Whether this court's statement is to look at the language of the opinion as a whole, the lower court's opinion, look at the language of the opinion as a whole, and then determine whether the prior court, the Superior Court where we filed the motion to enforce the agreement, determine whether they intended their decision to be preclusive. It cannot be, because the judge said your remedy is go file it in another court. So how can that is inconsistent, and that is right there in her order. So the interesting thing is that we argued at page 12 of our opening brief, when this court determines whether the first trial court intended the enforceability paragraph to be preclusive, meaning this agreement is invalid, the paragraph instructing us to refile the case should be decisive. If the trial court intended the paragraph on enforceability to be preclusive, it would make no sense to instruct us to refile in another court. Well, in their answering brief, the appellees never addressed that issue whatsoever. They don't mention anything about that. They don't mention it and they don't refute it. And so I cited in our briefs, we cited several cases at page 3 of our reply brief for the repeated holding, which is very common, that if a debatable issue is raised in the opening brief, the failure to develop or to respond in an answering brief of that debatable issue is reversible error, and in fact, that argument of the appellant is deemed admitted because it's not addressed in the responsive brief.
Can I ask a question? What's the significance of the ruling that there was a failure to prosecute in the first in the first proceeding, the first case? That we're not going forward because you essentially didn't show up for a conference that was scheduled. I'm reading the first result as it's procedural.
Right.
You didn't adequately prosecute the case. So if you don't adequately prosecute the case, you can just refile another case to prosecute it. There's no preclusive.
Well, in the lower court decision, the one that said to refile in another court, the hearing that you're talking about, Judge Katani, is a hearing regarding cross claims between the defendants. Had nothing to do with our matter at all. And at that time, we did not yet know that the defendants had reneged on the mediation settlement agreement. And by the way, if you look at the court records, the case was never dismissed. There is no order of dismissal. So,
But that was addressed in the first appeal, though. And this court said, well, there was still a fail. The court gave you an opportunity to explain, and the court said that the Superior Court didn't abuse its discretion by not granting the motion to go forward.
well, the court was wrong because it was never dismissed. The Court of Appeals, not this court, but it was wrong. It was a wrong decision. So we appealed to the Supreme Court and they didn't take jurisdiction. But it was a wrong decision. It was never dismissed. And there is.
But what can we do with that now? We're not here to revisit that rule.
No, we're not here at all about that. What we're here about is the fact that we had a mediation settlement agreement. The defendants reneged on it. We filed a motion within the same court, and the judge in that court, she said, go ahead and file. The applicable authorities required the court to leave plaintiffs to that remedy, meaning file a new complaint to enforce this mediation settlement agreement. File a new complaint, which we did. And then after we...
Is that a little bit inconsistent for the judge to say, go ahead and file a new complaint to enforce an agreement that I'm saying is there is no agreement, so
Well,
go ahead and file a new lawsuit?
Well, that's the case of, excuse me. That's the case of Pioneer that we talked about, where they say when you're looking at that decision, that lower court's decision, okay, the lower court's decision says, in the context of the opinion, it says that the agreement may not be enforceable, okay, may not be enforceable, but at the same time, she said, go ahead and file a new case. So you have to look at the Pioneer case very carefully and look at it, and it says in there that the language in an opinion, okay, to determine whether it's preclusive or not, you have to look at the entire opinion and then determine whether that particular language, whether one particular statement in the opinion makes it preclusive. And how could it if she said, go file in another court? You have to look at the entire language. And I would ask the court to, I know you've read everything, but that is very important in this matter because the opinion talks about a lot of things. So you can take a statement and an opinion and say, oh, that statement is preclusive of you doing this. Oh, that statement is preclusive of you doing this. But in her conclusion, when she says your remedy is to file to enforce the arbitration agreement in another court, you follow the judge's order. You follow the order and you file a complaint, a breach of contract, a complaint to enforce this agreement, which they reneged on. And that's exactly what we did. And then the appellees talk a lot about, well, you have to have all the terms of the agreement. Well, we did have all the terms of the agreement in the mediation settlement agreement, but that is really not the relevant issue. The relevant issue is intent, and there's a case, Shade versus Dietrich, that held it's not whether an agreement contains all the material terms that determines whether it's enforceable, but whether the parties intended to be bound by that agreement. So you saw paragraph 1, by our signatures, we intend to be bound by this agreement. And I'm talking about, Judge Williams, about the four corners of this agreement, which is those boards. So they intended to be bound by it. So the appellees never addressed our opening brief that talked about Shade versus Dietrich and said that, when you're looking at an agreement, you determine its enforceability by whether the parties intended to be bound by the agreement. So it's not about all the specific details to be determined later. And this is very common in arbitrations and mediations. You come up with an agreement, whether you call it an arbitration agreement, a mediation agreement, settlement agreement, you come up with an agreement, and very often the arbitrator will say, or the mediator will say, hey guys, here's the skeleton for it, work out the details of the final terms of the agreement to make it into a final agreement. So if they renege on it, we were supposed to go back and have Judge Stoller arbitrate the terms. But also, in our reply brief, we state where all the terms, they're on the board, but where all the terms are for the agreement. It was complete.
All right,
It was
Counsel,
very
your
detailed.
time is up.
Thank you, Your Honor.
Thank you.
Thank you. May it please the court. My name is Alex Park of Quarles & Brady, and I represent Monterey Tile and ProSource, but I'll be arguing on behalf of all appellees this morning. Respectfully, all things must come to an end, and appellees ask this court to put an end to this litigation between the parties, reject the argument raised by appellants seeking to compel arbitration, which has been rejected every time it's been brought by the numerous courts who have considered it, and affirm the Superior Court's dismissal of the complaint.
Counsel, is this an accurate summary of what happened? Judge Agni ruled that in the email, plaintiff's counsel said if there's a necessity to sue to enforce the agreement, there must be a separate lawsuit. Similar language, the applicable authorities require the court to leave plaintiffs to that remedy, meaning come back later. And then when they did come back later, the second judge said, oh no, Judge Agni's already resolved this. And so therefore one judge told him to come back, and then the other judge said, oh, you're too late. Is that what happened?
Respectfully, I would disagree with that characterization, Judge Kiley. I think that what a more accurate description of that exchange and that notation in the minute entry was that then counsel for the appellants noted that if he didn't get the relief he sought in the preceding lawsuit, he would file a new lawsuit, and the Superior Court was just acknowledging that he could attempt to do so. But of course, as Judge Catani noted a little bit earlier, that I don't think that was an endorsement or an encouragement, or certainly wasn't any instruction for appellants to file a new lawsuit, because of course in the final paragraphs of the order, the Superior Court says you don't have an agreement to arbitrate upon which you can seek to compel arbitration.
Okay, so Judge Agni in the next paragraph said there's no enforceable agreement, and then on appeal, this court said, oh, we don't need to address that issue because it's not necessary, which suggests that Judge Agni's finding is dicta. Isn't that what that suggests?
Again, I respectfully disagree with that as well. I think that the court, the Superior Court held in what I'll call Barrett 1, that I think it's helpful to contextualize the motion and the exchange in the entry order. So the Barretts, the appellants, sought relief from judgment, or effectively sought relief from judgment under Rule 60, and the Superior Court in Barrett 1 says effectively two things. One, I've looked at this case. I don't believe that you've articulated any basis under Rule 60 to obtain the relief from judgment which you seek, but separately, as an independent basis upon which I would deny your claim, I couldn't give you the relief that you sought, even if you did show this extraordinary relief was proper, because you have no arbitration agreement, so the thing that you're requesting from this court cannot be granted.
And you're saying the second is not dicta?
That's correct.
And if it was not dicta, why wouldn't this court have addressed it on the merits?
I think that I don't know that it would be necessary for the court to resolve it on the merits, because both independent bases could provide a reason for affirming the court. And so I believe that I don't believe the court would be required to revisit both rulings of the Superior Court if each one independently could provide a basis for affirming.
The issue preclusion requires a full and fair opportunity to litigate, right?
I would say that that's true.
And that requires, among other things, the opportunity to appeal.
I think that that's true as well, Your Honor, in a general sense, although I don't think that I would hesitate to suggest that the Barretts weren't afforded an opportunity to challenge Judge Agne's ruling in Barrett 1. I think that the Barretts raised their argument in Barrett 1 in the context of Rule 60. That argument was raised on appeal, and though the court did not specifically address the question of whether or not there was an underlying arbitration agreement, that argument was fully briefed, fully heard by this court. It just wasn't necessary to be resolved in that appeal in order to affirm the Superior Court's ruling in that case.
If this court said, we don't have to decide that to resolve this appeal, isn't that in effect a finding that determination was dicta? It's not necessary to the decision?
No, Your Honor, I don't believe that's so, because if the underlying, if a Superior Court has entered an order, and let's assume, for instance, it has explained, perhaps more than it should, and it has issued an entry or final order that says, I'm granting summary judgment for reasons A, B, and C. And let's assume this court believes that reasons B and C are wrong. This court can still affirm the summary judgment if reason A is sufficient on its own, and it need not then delve into whether B and C were properly decided. That doesn't mean that the litigants in that case weren't afforded a full opportunity to raise their claims.
What would happen if the judge had said you did have a binding agreement, if everything's set forth in this particular agreement, but you haven't prosecuted the case, you're not entitled to reopen, I'm dismissing it. So there's a finding that there was a binding agreement, but you didn't prosecute your case. So it's dismissed and it goes up on appeal, and then the ruling is simply the ruling that came out from this court affirming that the court didn't abuse its discretion by saying you don't get relief under the rule. Are you saying in that instance, this issue of whether there was a binding agreement, would they be entitled under those circumstances to file a separate lawsuit to say we want to enforce this agreement? The first judge says there was a binding agreement, but you haven't prosecuted this case, therefore I'm dismissing it.
I think that the answer would be in a circumstance in which the matter was fully litigated and appealed, and the decision of the Superior Court was never overturned, then we would be stuck with that. But I would kind of walk through that step by step to show why I don't think that would happen in the case, and why it would to try to break that down. And if, for instance, in this case, the Superior Court said, I'm not going to grant, in Barrett 1, not this case, pardon me. In Barrett 1, the Superior Court says, look, I can't give you Rule 60 relief. I think that there is an arbitration agreement here, but I don't think you've shown, you've not prosecuted your case, you didn't show up at the status conference, and therefore I can't give you any relief because the case is closed. We go up on appeal, and I guess both parties in that instance would go up on appeal, and the appellants in this case would argue then, well, the Superior Court was wrong, it should have granted our relief under Rule 60 and ordered the appellees to go to arbitration, and we would argue conversely, raise a cross appeal issue. We believe that the underlying decision of the Superior Court was wrong, and so that would end up forcing this court to resolve the issue at hand, because it would be necessary to determine whether or not this court could affirm the Superior Court below. But I think that the short version is, if the court said, look, you have a valid arbitration agreement and these people should go arbitrate, I think we would be stuck with that, but that's not what the court said.
Question, just a little bit more on issue preclusion as an affirmative defense. There's really four requirements for that. So I want to talk through each of those and then ask a question of you that I asked Ms. Horn. So the first one is it's the same issue at stake in both proceedings, and you would agree we're talking about the same issue here, correct?
As best as I can tell, that's true, Your Honor.
The second one is that there was a final judgment. It was actually litigated, and there was a final judgment. And you'd agree we have that here, correct?
I do agree with that.
The third factor is that there was a full and fair opportunity to litigate, And my question to Ms. Horn was, are you challenging, in this appeal, are you challenging your client's opportunity to fully litigate the enforceability of this settlement agreement for issue preclusion purposes? And she said yes. Do you agree that they've argued that?
No, Your Honor, and I appreciate the question because the only argument that appellants have raised on appeal, I guess two arguments. One is that they were somehow instructed to file this case by the Superior Court in Barrett 1, which we disagree with, and that the final statement of the Superior Court in Barrett 1 that the supposed arbitration agreement was not an agreement to arbitrate, it was dicta. Those are the only arguments they've ever raised. They have never once suggested that Barrett 1 did not provide them a full and fair opportunity to raise the arguments related to the arbitration agreement or the supposed arbitration agreement.
They did argue, though, that the Court of Appeals didn't address that issue, so they haven't had a chance to address, they haven't had a full and fair opportunity to address whether there was a binding agreement because the court's ruling suggested at least to this court that they didn't need to reach that issue just because they hadn't prosecuted the case.
I respectfully disagree with that, Your Honor, and the reason why is I don't think that them saying, the appellants in their brief do note that the Superior Court, or the Court of Appeals in Barrett 1 didn't reach a final ruling on their motion to compel arbitration arguments. But they never once suggest that they were denied an opportunity to be heard. They never suggested any of the elements of issue preclusion were not met. In fact, they don't argue that anything from the Superior Court's order wouldn't bind them in this case. They only argue that in terms of the holdings of the order in Barrett 1, the only thing they've ever argued is that the holdings don't preclude their arguments here and that anything that is helpful for us is dicta. And so
So they are challenging one of the elements of issue preclusion, whether it was necessary to the decision.
I think that that's true only insofar as they're saying that the court in Barrett 1 didn't reach the issue that we are talking about, or it was not an alternative holding. So to the extent that they're arguing on appeal, the statement from Barrett 1 that there is no agreement to arbitrate, it was not an alternative holding, but was in fact dicta and therefore cannot be binding because, of course, dicta is never binding. I agree that they preserved that and raised that with this court, but they've not raised any other argument with this court. They've not challenged any other element of issue preclusion, and they certainly haven't given us an opportunity to rebut this suggestion that they weren't given a fair opportunity to litigate the case.
Let's say there's absolutely zero question that there's a binding, that there's an agreement, that parties have reached an agreement. They reach it as part of this underlying, the previous litigation, Barrett 1, but there's an agreement now. Why isn't there, or is there an opportunity for an independent lawsuit saying we now have an agreement? Whether we can go forward with the lawsuit that we have under Rule 60 or whatever the procedural posture was is separate and apart from the issue about the issue of whether we have we have reached a binding agreement. If we can look at this document and say there's an agreement, we now have a contract essentially, and we can bring a breach of contract claim.
I think on that question, Your Honor, I'm not sure. That's not something that's been raised by the Barretts in this litigation, and so I just don't know that I'm prepared to suggest one way or the other that they have some alternative claim that they've preserved, but they could have, of course, brought such a claim in this case and did not. But I think that
isn't that sort of what they did, though? They were saying we're entitled. We have to file a separate lawsuit because we have an agreement. We think this is an agreement. The agreement just says if there's any disputes, it just goes to one person who makes the. So they're treating it as that we have a separate contract with the other side, and we're entitled to pursue a breach of contract claim.
I don't think that that's what they did in this case, Your Honor, and mainly because that's not how they couched their complaint. Their complaint solely asked the court to send, and this actually leads into a point I do want to make sure I raise with the court today. Their complaint for arbitration says, effectively, we've had a previous lawsuit, we attempted to arbitrate something, the thing being unknown, and please send us to arbitration in this case instead, because the court in the first case wouldn't do so. And they didn't suggest that they didn't raise any independent breach of contract claim. They didn't seek to enforce anything other than the supposed arbitration agreement, which of course we contest. But I think that I want to point out that that provides a separate independent basis to affirm the decision below, if only because even if you take the appellant's argument at face value that there was an agreement to arbitrate, that agreement to arbitrate was extraordinarily narrow, if it existed at all. It was only about what final terms would exist in the final operative settlement agreement. And so the way that we read that is assume, again, we can test this, but assuming that they're right, there is an arbitration agreement. If the parties couldn't agree on the final terms, you send it to Judge Pro Tem Stoller, who would then write the disputed term and write the agreement. That's the only thing that Judge Pro Tem Stoller was authorized to do under the supposed arbitration agreement. In this case, and in the complaint to compel arbitration, and in fact, nowhere in this record do plaintiffs articulate, do the Barretts articulate what it is they seek to send to Judge Pro Tem Stoller, what terms are in dispute, if any, and what they're asking the court to send to arbitration. In fact, in their reply brief, the appellants suggest that this is an overarching arbitration provision covering any and all disputes between the parties, but that's simply not possible. It's not possible to grant them that relief and send any and all disputes over. I think it says in the Superior Court's order in Barrett 1, they attempted to send to arbitration the implementation of the settlement, whatever that means. That's far broader than anything that was agreed to, even assuming that the term sheet was binding, which, again, we contest.
But wouldn't there at least be an opportunity to send something to the Judge Pro Tem and say this is what our disagreements are. We want you to rule.
Well, I think
weren't they denied that opportunity?
Well, they weren't. Well, and to make clear, we dispute that there was that's an arbitration agreement at all, and that there was because effectively it is what I just said. I know it uses the term arbiter, and I take that. But it effectively says that the parties can't reach a resolution if the parties have a dispute as to the terms of the final operative settlement agreement, which would be the operative settlement document that would control and bind the parties. You can send it to Judge Pro Tem Stoller, who will resolve that dispute. I don't think that's typically how I consider an arbitration agreement. I understand arbitration can be broad, but typically it involves a claim of some sort where parties will present argument between the parties, not what effectively is a third-party neutral saying, well, I'll write a mediator's version of the settlement.
And could I ask, Ms. Horn referenced cross claims. What's your view of what were the cross claims?
So that's not related to this case, Your Honor. The reference to cross claims is the Barretts and the appellants in Barrett 1 suggested that they weren't obligated to attend the settlement, the trial setting conference that resulted in the dismissal of their claim because that settlement conference was related to cross claims. That's not in this record, and I don't believe it's relevant to any of the issues.
Were there cross claims?
Honestly, Your Honor, I don't know off the top of my head whether there were cross claims in that case.
But wouldn't it be significant if the cross claims involve are just between multiple defendants? Is that seems to be what's being suggested? Or there?
My understanding of Barrett 1 was that there was a tentative settlement between all parties and all claims, and that there was nothing else pending until and again, I know this is outside of this, but the Barretts repudiated the settlement and then failed to litigate their case.
Let me just go back to the dicta issue. In Barrett 1, this court, in the appeal in that case, this court said, the Barretts offer argument that their settlement agreement is binding and enforceable, but we need not consider the argument because it does not affect whether the Superior Court abused its discretion by denying the motion to reinstate the case. Isn't that the definition of dicta? I mean, didn't this court already say that what Judge Ogney had to say about the enforceability of the agreement is not necessary to her decision and in effect is dicta?
No, Your Honor, I don't think so, and it's for the same reason I stated earlier. If in many instances, both trial courts and this court note that there are multiple reasons upon which relief can be granted or denied. And if a Superior Court raises or mentions in its reasoning multiple reasons for why it's issuing the order it's ruling, and let's say one of them is correct and 5 of them are wrong, this court need not delve into the other bases to grant relief because each one can provide a separate independent basis.
Yeah, but under that fact situation, each one would not be subject to issue preclusion. The plaintiffs would not, if the trial court rules on issues 1 through 6, this court affirms on issue 1, it's not the case that 1 through 6 are all binding and preclusive in future litigation.
I don't know that I fully agree with that, Your Honor, but because that's not something that's been raised in this case, I'm not saying that that's wrong, but I don't know that that's right, and I'm not sure that certainly plaintiffs have never suggested that has any import in this action.
Well, I think that they did, because they said that this second paragraph in Judge Ogney's ruling is dicta and it has no binding effect.
Well, I take that point, but again, and I hate to repeat, but I think that the reason why I'm so hesitant and reluctant to say that that was somehow a dicta is because I think read fairly, the final couple paragraphs of Judge Agnews' order were, look, I can't give you Rule 60 relief because you let your claim die. You didn't continue to prosecute it. But even if you had, I couldn't do what you want me to do because you have no agreement to arbitrate. And I think that if a court says that, it's issuing two independent alternate basis, which, for instance, if on appeal the court found that there was an abuse of discretion by denying the Rule 60 motion and saying that there weren't the elements met to seek relief under Rule 60, but then independently the court could affirm anyway, because it says, but in any case, we review this decision about whether there was an underlying arbitration agreement, and we affirm the Superior Court, and then it would be binding. I don't think that the decisions and issues that this court decides to rule on when it affirms the Superior Court are necessarily impactful when it comes to issue preclusion. With that, unless the court has any further questions, we would respectfully ask that this court affirm.
All right, thank you. Counsel, thank you for your arguments. We will take this matter under advisement and issue our decision in due course. We're adjourned.
Okay.